Hi, everyone. Thank you so much for joining us today. Thank you for joining the NC Leap webinar hosted at the NC Bar Foundation. Today's topic will be on data privacy and cybersecurity. I would very graciously like to thank Clara Cottrell, Senior Counsel for Compliance and Privacy at BASF Corp. Clara focuses her practice on data privacy and security, and Suzanne Begnoche, who represents consumers in a variety of practice areas such as collection, harassment, credit reporting errors, identity theft, security breach and debt collection lawsuits, and many more topics. We are very excited to have them here today, and I will turn it over to them.
Thank you so much, and thank you for having us today. So like Carson said, this is going to be an overview discussion, and I do want to start off by saying that this presentation reflects the personal views of the speaker in our individual capacity. It does not necessarily represent the views of our respective organizations or employers. The information here is intended for informational purposes only and should not be construed as legal advice or a substitute for obtaining legal advice from an attorney. Information is based on our current interpretation of recent developments and its implications on businesses. But this is a very fluid area, and further changes and variations in interpretation remain very likely. Next slide, please. So we're going to walk you through a couple different items. We're going to start with a conversation about privacy versus security, then talk about some very special categories of information and what information might be involved here. And then from your perspective as a small business, what you might be worried about, including some best practices to help you get there. Next slide, please. So data privacy and data security. So as you can see from the title of this slide, data privacy and data security together are what we consider data protection, but they are actually separate topics. When you look at data privacy, what you're really thinking about are the rights of an individual, how you collect their information, how you process, which is use or treat it, the way you store it. All of that is information about a person, their rights, so their data privacy. And then also you have to do it in a certain way that complies with laws and regulations. So if the personal data about an individual and how you handle it and store it is data privacy, the data security on the other side is how you protect that information. So what are the technological and organizational measures, or TOMs, you might hear that called sometimes, that ensure the integrity and confidentiality of personal data? And of course, data security also comes with laws and regulations related to how you're going to do it. So those two things together are data protection, and we're going to talk about both in different ways. Next slide, please. So here are some examples of personal data, and you see this is the global edition. Data privacy and the concepts around data privacy and data protection are really throughout the world at this point, which I'm sure you all know. And what personal information means could be different depending on the jurisdiction of where the person is that you're collecting information from, or your jurisdiction. So North Carolina, the United States, for example. So on the left-hand column here, you see what are some typical personal information and personal data examples. Some of them actually you might not think are typical, such as the information related to where somebody works. Looking at personal data more broadly, if it's information that can be used to identify a natural person, then it's probably personal data. Now, the column on the right, the potentially sensitive personal information, is information that is treated with a higher level of sensitivity and security, going back to protecting personal data. And as you can see from this list, they're really focused on the types of information that could be used to steal somebody's identity or to discriminate against them. That's why these are considered more personal information. Next slide, please. So where are these things being protected, either data privacy or data security wise? Well, on the security side, everywhere. So you need to be aware of that. But as far as comprehensive data protection laws, so laws that are really related to data privacy and the security of that information, we're really looking at right now 3 main jurisdictions in the United States. We're not going to do this across the world. So the California law was introduced and then became effective January 1st of 2020. So that's the one that we've been living with now for a couple of years. However, Virginia and Colorado have recently passed their own comprehensive data protection laws. They go to effect 2023. And then, I'm sorry, the CPRA is the new California update to their California law. That goes into effect January 1, 2023. Colorado goes into effect July 1, 2023. There's a lot of acronyms and they're all very similar, unfortunately. Now this chart here, we wanted to give you this information so that you could see that what the scope is for these laws is actually a lot more limited than you may think. So do take a good look at when these laws might apply to you. And if you don't have a gross revenue of 25 million, or you don't have 100,000 people's information in a calendar year, they might not apply to you. Always be careful, because there is a potential of fines and actions from either an attorney general or a designated governmental agency if you do fall into scope and you're not in compliance. So if you think that you might be, definitely consult with an attorney. Next slide, please. Now, I said that there's only 3 states right now, but what you can see from this map is there probably is more to come. In fact, Utah should probably be yellow. So this was last updated mid-February. They now have their data protection law has passed both chambers and is waiting to be signed by the governor. So pretty soon, Utah's probably going to be a red state. You should also notice that North Carolina is in there. There has been some movement in the legislation related to a comprehensive data protection law. We'll have to keep an eye on that and see where that goes. Next slide, please. Now that you know that you might be in scope or you might not, that is really for that comprehensive data protection laws, right? Well, there's other categories of information that are impacted not in those comprehensive data laws that we've been talking about on the state level, but on the federal level as well. So, children, there are federal and state laws that deal with your ability to collect information from minors. Now, I want to note that does say from minors. That's most of where the emphasis is going directly to a child and getting information from them versus going to a parent and getting information about the child, a parent or a guardian. Now, this is the kind of information, though, that I would consider more sensitive because it is about children. So do make sure that you understand what you should be doing to protect that kind of information. And you should also think about whether you should have children in your social media, any of your publicity and marketing materials. Be aware of the copyrights and rights of publicity that could apply there. Now, financial information, hopefully, or most of you probably aren't going to fall into these. So the Graham-Leach-Bliley Act is really related to financial institutions and how they protect your financial information. The Payment Card Industry Data Security Standard is related to like the Visa cards and how you're going to be processing payments at a point of sale, for instance. And the Fair Credit Reporting Act identity theft rules really relate also to how you're handling information from your customers. Now, healthcare and medical information. I'm going to take a second to talk about that one, mostly because you've heard it around a lot lately. So HIPAA is the Health Insurance Portability and Accountability Act. And nowhere in there do you see the word privacy. Just want to make that clear. So that HIPAA the act was really directed to insurance companies, right? And also to healthcare providers. So the idea there was to make sure that healthcare providers like doctors' offices, hospitals, dentists, are all treating your information in a way that protects it and they don't share it outside of who you, the person who's being treated, has given authorization for. Same thing with insurance companies. It does not impact whether an individual chooses to share health information about themselves outside of that context. So if you are not a healthcare provider and you're not an insurance company, it is highly, highly unlikely that HIPAA applies to you. HIPAA would not apply if you are an employer asking your employee a specific piece of information about their health. However, Americans with Disability Act might apply. So if you do have an instance where an employee is coming to you and saying they need special accommodations because of a medical issue, make sure you're up on your ADA regulations and what it is you should be doing to help them, to talk to them, and to accommodate them. That anytime that any of these are impacted, children, financial information, healthcare, medical information, definitely consult with an attorney about what you might be needing to do. Next slide, please. Another topic that we wanted to really touch on, even though it's a little bit outside of the privacy realm, is really how you handle your website and your online presence. And that's because anything that's out there on the internet is also an ability for you to collect information. So you do need to think about your websites and your online presence as one of those avenues where information could be collected, therefore one of the avenues where data privacy and security could be impacted. So first, privacy policies. Most websites have a privacy policy. It's a good thing. It's recommended by the FTC, but there is no federal law that says you have to have a privacy policy, excuse me. However, if you are offering services in California, for example, and on your website, you're collecting information about the people who are visiting your website and they're California residents, well, then you do need a privacy policy under the state laws. So that's why most websites have a privacy policy, even though they technically don't have to across the board. Now, the privacy policy that you have, though, what it says is your promise to people who are using your website. It's what you telling them externally, what it is you're going to be doing with their information, how you're going to be treating it, all of it, how you're going to store it, the security around it, all of those kinds of things. And if you're telling somebody that, and then they use your website and give you information or just use your website, quite honestly, well, you now have a contract. And if you break your promises, if you don't do the things that you did say that you were going to do in your privacy policy, well, now you've probably breached your contract. So that could be an unfair and deceptive trade practices. Now that is when the FTC gets involved because they really don't like that. So I'm telling you this to make sure that you know you shouldn't be just going to anybody else's website, copying their privacy policy and slapping it on your website and saying done. You need to really look at it and think through, are you going to be able to do the things in it that you said that you were going to do? And if you cannot, you should not say it. You're going to hear a little bit more about this with Suzanne a little bit later too. Now, websites, cookies and targeted advertising, right? It's every marketer's dream. You learn about the people who visit your website, what their interests are, and then you can push ads to them no matter where they are. It sounds great, but it's also slightly invasive, which is why we're getting more and more regulations related to cookies and targeted advertising. I'm going to talk a little bit about that on the next slide, but the next slide is going to be mostly for informational purposes. So you'll get some more information about that. But there are state data protection laws that are going to apply to your use of cookies or the targeted advertising. So be aware of that if you fall in scope. Now, copyrights. You know, it's not really a privacy issue, but it is important to know that just because there's a picture online does not mean you can use that picture any way you want. Make sure that you have the right permissions or releases to use photography or other creative expressions like artwork and music. All right, so you have this great website, you're getting traction, people are checking you out, and you want to engage with them more. Maybe you want to have a channel, maybe you want to have a business page on a social media site, you know, anything like that. Make sure that you have looked at the rules related to how you engage with people on your platform, whether you can direct message them or not, whether you can post information directly, whether you can tag people, all of that kind of information is going to be in the platform, and each platform is different. When we're talking about the data privacy and protection, remember we're also talking about it includes that once you have information, you have to keep that information secure. Well, one thing you might consider is asking that direct messages to you via, you know, whatever your online engagement is, do not contain personal information. And then if you did receive it, you are going to delete it. The best example of this is actually if you look at any law firm's website and the contact us tab, you know, it has a little form for you to fill out most of the times. And then at the bottom, it says, you know, please don't provide us with any, you know, sensitive or personal information. and this does not make an attorney-client relationship, basically. So it's sort of that kind of idea. Now, marketing emails too. So once you have this platform going and you're collecting information and you want to send emails maybe out to folks, that falls into another category of marketing, and you need to make sure there's certain information in those emails, including the ability, of course, for somebody to unsubscribe. And there's another slide a little bit later talking about this just a little bit. So make sure that if you are sending out marketing emails, you know what the restrictions are. The FTC has a really good website and a lot of information that you can use. And finally, social media influencers. So if you are social media influencers, or if you want to use social media influencers as part of your marketing campaign, make sure that you and they comply with the FTC requirements related to how the influencer has to disclose and be transparent about when they are actually advertising a product versus speaking on their own. The FTC has actually been cracking down on this quite a bit lately. So again, go see their website. They have some really good information and some assistance there. Next slide, please. So I had mentioned the cookies and targeted advertising. We're not going to go through and talk about this entire slide at all, but what these are, the sell, share, and the cross-context behavioral advertising, otherwise known as targeted advertising. These are definitions and some of those data protection laws that we talked about at the beginning, California, Virginia, and Colorado. The reason I bring these up is that if you were to fall within the scope of any of those laws, using cookies and targeted advertising impact you when they fall into these categories, the sell, share, or the behavioral advertising. So if you think you are in scope, these are really important, because if you fall within these categories of activities, if this is the things that you are doing, then you have other obligations besides just, keeping the information secure. And little tip here, sell doesn't mean what you think it means. It's not just about money, it's about any valuable consideration, which is where the advertising comes in. Next slide. So really quickly, I also promised that we would say a couple words about that email marketing. So in the United States, there's no federal requirement in order to get consent or have to have consent in order to email somebody a marketing communication. The Can Spam Act, though, says, right, you need to be able to have a mechanism for unsubscribing people. It has to work, for one thing. So make sure you have those in your emails. Other countries, though, do require affirmative or at least implied consent that has to be gotten before you use the contact information for any marketing communications. So, if you're going global, this is something that you're going to have to pay a lot of attention for. Also, texting. In the United States, texting marketing communications does need prior consent. The TCPA is the law at issue there, and there are pretty heavy fines related to texting without clear consent ahead of time. So we've talked about all of these different areas of data protection and security, what it might apply to, and how you possibly could be in scope. So we're going to go over to Suzanne to talk about what happens if you are, and what are the things that you need to look out for? What are the risks that you could incur? Next slide, please.
Okay, so Clara just talked a lot about different data protection laws and privacy regulations. So the bad news is that's a lot of information to digest, and a lot of laws that are probably just bouncing around in front of your eyes right now, where you're worried, do I need to comply with this? Do I need to comply with that? The good news is that in most instances, a breach of a privacy law or a data breach that occurs at your business is not going to be sufficient for the people whose information is involved to just go right out and sue you over it. In most cases, an individual has to show that they've actually incurred some sort of harm as a result of an incident. And so looking at sort of a graduated level of your risks here, if you violate a state privacy protection law, you may get a complaint, and then the state attorney general or another state agency may become involved, and they may look into it, and you may get some sort of inquiry letters. But for the most part, unless you're one of those large scale businesses that Clara mentioned that is already dealing in large volumes of data, the state laws may not even apply to you. If you violate a federal law, you may get inquiries or maybe looked into by a federal agency. So Clara just mentioned, if you're an online influencer, you need to be aware of advertising restrictions. And so if you don't follow those, you may hear from the Federal Trade Commission looking into you. Again, for my considerations as an attorney representing individuals, that's lower on the scale of risk for the business. The next level is a state law security breach. So every state, including North Carolina, actually has laws in place that may be triggered if a state's resident is impacted by a security breach. So that's above and beyond that table that Clara showed you about. There are a few states that have laws governing collection of data. This is a little bit different. Every state has a law that says, if you're a business and you meet certain threshold levels, you have to do certain things if there's a data breach of your customer information. And so that's a slightly larger risk level for you in terms of what you're going to need to do if this happens to your business. And lastly is civil liability. And that's what I, as a private attorney, deal with, representing folks on the consumer side. So this is where you may have a data breach, and if a person whose information is affected by the breach is actually harmed, you may get a lawsuit over that. And so harm could be out-of-pocket expenses that result. So for example, maybe the consumer has to go out and buy credit monitoring because they're worried that someone may use their personal information as a result of the breach. If the consumer experiences some sort of financial fraud because hackers got their data, or if they have some other kind of concrete invasion of privacy, those may all give the consumer grounds to sue you. Next slide, please. So I'm going to talk just a little bit about what the potential lawsuit claims might be, and then the remainder of the slides that I'm going to go through with you, we'll talk about what you as a small business can do to avoid having these types of claims. So one type of claim after an incident might be that the business was negligent in how it protected the data. And negligence is just the legal term basically for failure to protect data, carelessness. So an example from my practice involves a healthcare provider in the local area, a medical office that didn't put proper firewalls in place and didn't monitor incoming traffic on their network. And as a result, hackers were able to get into a particular server, steal their patients' data, and some of those patients had their identities stolen and used to set up credit card accounts. So that's sort of a run-of-the-mill example of what can happen if you don't have proper safeguards in place, and the type of lawsuit that could occur. Basically, a filing in court that says you were careless to these folks whose information you had a duty to protect. Another example of a type of lawsuit that could occur is negligence in hiring and supervision, which resulted in the data breach. This doesn't have to do with folks coming in from the outside and stealing your customer or employee or client information. It has to do with who you've hired and your ability to vet those folks. So an example that I'll give you from my practice was a business hired someone who had some embezzlement convictions in their background. And embezzlement means they had stolen money from a prior employer. This individual ended up having access to their customers' banking information and used some of that banking information to access the customer's credit cards and make illegal bank drafts from the customer's accounts. So that's also an example of a breach of customer information, but one that comes from the inside. Another example is something that Clara mentioned earlier, which is a breach of contract by a business when it fails to protect the data or fulfill its promises in any contractual relationship. And that includes the privacy policy or the terms of use for any website or service. It can also involve what's called an implied contract. So something that's not in writing, but sort of implied from the fact that you're engaging in a business relationship with an individual, that that guarantees them certain rights that you have to follow, even if it's not in writing. An example of this from my practice was a car dealership, which had a website where folks could apply for financing if they saw a car that they liked online. So click on the vehicle you like, a pop-up comes up and says, would you like to buy this vehicle? We can set up financing for you. And they had a privacy policy on the website that talked about what they would do with application information if you did not follow through and buy the vehicle. Unfortunately, this business did not adhere to its privacy policy about that information. And financing applications that prospective customers filled out that were not destroyed and not taken care of in the way that the business said ended up being obtained by a third party. And that individual was looking to meet women and started calling the female customers and harassing them using the telephone information and the names that they got from these financing applications. So that's another example of a data breach that can occur. That would be a breach of contract from the privacy policy that was advertised on a website. Another type of claim is, the legal term for it is intrusion into seclusion. That sounds very obscure. It just basically means when a consumer has an expectation of privacy for their information and the business does something that causes that expectation of privacy to be violated. An example that I've had from my past work involved a business where this wasn't actually customer data, it was their own employees' data. So this particular business, because of the way that they paid for the employees' health insurance, actually stored some medical records related to the employees. And a coworker just got into those records and was looking at them and found out something about her fellow coworker and started gossiping about it in the workplace. And that was obviously very violating for the person whose medical information that was, to have all of her coworkers know about this and to be the topic of gossip. So that's another example of a privacy violation, and that would result into what's called an intrusion into seclusion claim. Lastly, there are a number of privacy and data protection laws. As Clara talked about, in North Carolina, there's not a privacy statute set up, but there are various laws that do relate to privacy in one way or another. And like I said, there are laws that cover what has to happen when there's a security breach. One of these laws related to privacy has to do with when a business has customer information, how they dispose of it. And this relates to paper information. So for example, if you collect customer information that is considered personal identifying information, such as social security numbers, the North Carolina law requires that when you discard that information, you have to destroy it in certain ways and ensure that the destruction does not offer any unauthorized person access to it. And the example that I've seen in my practice was, rather than shredding those types of records, the business just threw them all in the recycling bin, which sat outside the physical premises. And this enabled someone else to obtain those records and use them to sell the employees' identities to people that were looking to work under another identity, perhaps as a result of not having proper clearance to work in the United States. So all of that, I've just given you a parade of terrible things that could happen that could result in potential claims. So if we move to the next slide, we'll start discussing what you can do to prevent being in that type of situation. So best practices. First of all, as a small business, you need to know your risks. So perhaps you're not dealing with 100,000 customers yet. Perhaps you're not bringing in millions of dollars in revenue a year, but you need to know and control who has access to whatever customer data and employee records, basically any information that you keep that relates to an individual. You need to know who is accessing that and be able to,
Sorry, Carson, I think you might be
something up
showing
on the
the
screen.
wrong screen there. There you go.
Okay, thanks. You need to know and control who has access to that information. And if you're hiring employees and those employees are going to have access to that information, you should conduct proper background checks, do proper vetting so that you know who you're hiring and what the risks are of hiring that individual. And you also need to be able to track who in your company accesses what type of information. And lastly, you'll want to create some sort of security policies and procedures. And, obviously an attorney can help you do that. We're going to provide you some resources at the end of the presentation where you as a small business can get some ideas on your own for sample policies and procedures. But you need to have all that in place so that you know what your risks are. And again, as I mentioned, it's not just who gets on the computer. It's paper data as well. So any type of paper that you keep that contains records of individuals' information, you need to know and control who can touch those papers, and you need to have a way of tracking who is accessing them, who is going into the file cabinet where that information is stored. And especially during the pandemic, where a lot of us have been working from home. If you're just starting your business, you may be starting your business from home. And it's sort of obvious, but I do feel the need to say it, is we have our kids or our spouse or other folks in the home that, if our business is here on our laptop, other people may be using that laptop. So think about that as well. It's not just folks that work for you or that you're paying to do things. It includes, where if that data is portable or if you're working out of your house, just be aware of your family members who may do something by accident that they shouldn't do that could put your data at risk. Next slide, please. So once you know what your risks are, you need to set up protection. You need to be able to protect that data, take appropriate steps. And this is one of the big things that I, as an attorney, look at. When some customer comes to me and says, my information was hacked and it was being stored by such and such business, I want to start investigating that business and seeing what did they do to protect that information, to see if they were careless with it, to see if they took the proper steps or not. So you need to train all of your employees on information protection and how to avoid hacking. There are a lot of steps you can take from the IT standpoint, and I'm not an IT professional by any means. You're going to want to work and consult with someone, at least in setting up proper information technology for cybersecurity protection. But the basics would be that you're backing up your files regularly so that if there is an incident, you can recover that information and you know whose information is affected. Install all the security patches that are necessary for your software and your services, and use firewalls and make sure you have a secure network. You want to encrypt data to the extent that you can, and limit emailing of sensitive information. That's a big one. And when you're done with data, like I said, there are some laws that are going to require you to keep certain customer information for certain lengths of time, depending on what your business is. But when you are ready and it's lawful to do so, you need to make sure that you destroy that information and any media that it's on appropriately. And by media, I mean laptop, zip drive, even a phone. If your phone contains customer information and you're getting a new phone, you need to make sure that you follow proper practices to wipe that old phone and before you dispose of it or destroy it. So all of that's important, and those are areas, like I said, where you may want to have a cybersecurity consultant come in and work with you so that you can put appropriate protections in place based on your business needs and the size of your business and who you're dealing with. Next slide. All right. The third best practice is to prepare. You need to prepare for potential security incidents. None of us want to have this happen, and we're all going to have all of these firewalls in place and vet our employees, and we're going to do all the best things that we can. But sometimes even the best knowledge and the best protections aren't enough. And so we need to have preparation. And one of the number one preparations, obviously, is the security breach plan that we talked about. Have those policies and procedures in place for protecting data, and have policies and procedures in place for what are you going to do if there's a breach. The other thing that you want to do, and I emphasize this really strongly, especially as a small business starting out, is look into cyber insurance. What is cyber insurance? That is going to protect your business and cover your potential losses from customer lawsuits if there is a data breach incident and a court finds you to be at fault. It's also going to cover, depending on your policy, will cover your ability to recover data and set up other protections that you may need. It sounds expensive, I know, just because of the word cybersecurity, that most of us don't really know what that is. But in North Carolina, a policy for business cybersecurity averages, I just looked it up this morning, averages $1,400 a year. And I saw policies advertised for as low as $400 a year for a business. So it's something that you should definitely look into as early on as possible. Talk with a knowledgeable insurance agent and get a special cybersecurity policy for businesses. If you're a homeowner or a renter, you may have some cybersecurity insurance included in your homeowner or renter policy, but those may not be sufficient to cover business losses. So don't just rest secure thinking that you as a homeowner already have that and that it's going to cover you because you're working out of the home. You need to talk with the insurance agent and make sure what you have and what type of coverage you may still need to purchase. Next slide, please. Best practice number 4 is monitoring. It's not enough to have antivirus software and firewalls and programs in place to filter your email if you don't follow through with monitoring what's happening with them. So again, this is something that a cybersecurity or an IT consultant can talk about with you some more. And depending on the needs of your business, you may outsource these services to a company that specializes in doing cybersecurity for you. But basically, all of these programs are going to have some sort of logs that track any types of attempted incidents or incidents And you want to have somebody that's looking at those logs and monitoring them to alert you if your network is being attacked, or if there's somebody that's been trying to log in to something, even down to the level of your laptop. And for physical documents, you might want to have premises that require badging to enter, or some type of verification system to access the room where documents are kept, or at the very least, some sort of premises monitoring or alarm system. So video that shows, that clicks off anytime there's movement, that's going to take pictures of who's trying to get in, so that at least if there is an infiltration, you have some evidence that you can follow through with to try to find out who got that customer information and have law enforcement help to recover it. Next slide, please. And the last best practice that you want to look at is how you respond to security incidents. And again, that's going to be part of your security breach policies and procedures that you want to have already set up. But those should include implementing that plan. And that may include, like we just mentioned, using third parties to help you stop the outgoing flow of that data that you need to protect. So that could be law enforcement helping to determine who was the perpetrator of an incident and how to identify them and locate them and recover the data. Cybersecurity consultants and other IT professionals to help you recover data. You're of course going to want to report to your cyber insurance carrier if it's applicable, if it's a data breach. You want to notify them of the incident. And that's so important because some policies, most policies are going to have some sort of provision that says you need to notify us as soon as you know that something might have gone wrong. The longer you go without letting them know that, you put at risk your coverage. And they may say, you waited too long to let us know about your claim. We're no longer obligated to help you. And you want to notify, most important in terms of avoiding suits from consumers, you want to notify anybody whose information is affected in a timely manner in compliance with the law, probably as soon as possible. So like I said, North Carolina has some security breach laws that affect businesses of certain threshold sizes. Even if you're below that threshold size, from my perspective as an attorney, you still should take a look at what North Carolina law says and use that as your standard or your guideline to make sure that you're letting customers know, or affected employees or whoever else's information is involved. And you should, at the very least, considering paying for them for credit monitoring so that they have that assurance that they're going to be able to check from their end to make sure nothing bad is going to happen with their data. And next slide, please.
So Suzanne just talked a lot about sort of the security portion, but I also wanted to talk just briefly about data privacy sort of overall, conceptually, right? So when you're thinking about using information, only use personal information in accordance with your privacy policy. And your privacy policy might change over time, so you should probably keep track of what applies when. But please don't assume that any use of information that you have about anybody is okay. You really need to think about all those laws we just talked about, all the obligations that Suzanne went through, and then what you say in your privacy policy. Next slide, please. Same thing for sharing information. So if you have personal information, you should have some controls related to how you're sharing it. This is similar to what Suzanne was talking about with access controls. Who receives the information, who can get the information. For example, you might want to share personal information with another business because you're going to do marketing together, something along those lines. You need to make sure you have some safeguards in there to protect the information in your contract. Please do not just give information out willy-nilly. Next slide, please. Now, we've talked about a lot of different things right now. We've talked about all the ways that we would hope that you spend some of your money, everything from talking to an attorney, talking to cybersecurity experts, and all of the software and firewalls and everything in between. And we know that for most of you, having disposable income that you can put towards that, as opposed to your business, isn't always possible. So what we gave here are some resources. So these are all different agencies and organizations that include information for businesses to use to help get them on the right path. So things that you can do yourselves. Some of them are white papers. Some of them are templates, other resources, even guides for what you should be doing, when, how to do it, and what you really should be looking out for. So if you can start there, at least you'll be on the right foot and you'll be in the right direction. And then as the time comes, really do look at what else you might need to add to the DIY that you've done at that point. Next slide, please. So we're at the end, and we're happy to take any questions that you all might have. So of course, I'm not sure if any came in that you want to ask us.
Hi, yes, we actually did get a couple of questions. While we go through this portion, if anyone has any other questions, please post them in the chat or the Q&A function and we will get to them. One question that was asked at the beginning that you might have covered, but doesn't hurt to go over again. What kind of insurance is needed to protect clients' information?
Well, I would recommend a cyber insurance policy, which is what I mentioned as part of your planning and preparation for the possibility of a breach. And so if you don't have any type of insurance already, you can just Google. Most insurers now offer cyber insurance. And depending on what industry you're in, you may have an industry group that actually caters to your type of business that may also offer more specialized policies. So for example, for me as an attorney, North Carolina has some lawyers associations that actually offer very attorney specific policies. So check into that as well.
Thank you. Another question that was asked was, if my LLC is registered in Colorado, but I live in North Carolina, do I need to comply with Colorado law?
Well, yes, probably. I mean, if you're talking about Colorado law in general, yes, right? You now have a business in Colorado. It is subject to Colorado laws. When you're talking about the data protection laws that we were mentioning, that I mentioned earlier, you do need to look at the scope. So I think they're still at 100,000 consumers. So do you have personal information about 100,000 people in Colorado, by the way, because consumers usually limited to residents of the state where the law is coming from. So it's highly likely, yeah, that you are. If you think, so if you look at this again, or I'm not sure if the slides are available afterwards, look at that scope page that had the 3 laws. Check out what Colorado had. There's resources that I was talking about on the last slide. The IAPP, the International Association of Privacy Professionals, has a lot of good information. Law firms usually write them, or other cybersecurity professionals, and they have a lot of walking you through whether or not you may be in scope or not of a certain law related to data privacy or security, of course.
Thank you. Are there any other questions? All right, well, thank you so much, Clara and Suzanne. This was incredibly helpful. I hope you both have a great day, and thank you all to the attendees who were able to join us this afternoon.
Thanks again for having us. Bye.
Thank you.